Okay, so imagine for a moment you're caught up in a really high-stakes legal situation. The pressure's on, yeah, courtroom's quiet, and you're not going in with a typical lawyer's playbook. No. Instead, you're armed with this, like, deeply personal, almost philosophical take on the law. You're convinced you can actually reshape the whole thing. Today, we're doing a deep dive into some really fascinating material someone shared with us. It's a transcript from a YouTube video, actually. It details one person's, well, remarkably unique way of trying to navigate the justice system.
Yeah.
We're talking about Christopher, that's the name he uses, and it's his own account, firsthand, of trying to use these very specific arguments in court. And he's facing charges from, driving without a license right up to reckless driving.
Right. And our mission here for this deep dive is really to unpack the core ideas in Christopher's account. We want to look closely at the strategies he used, the specific language he chose, and the beliefs he holds underneath it all about, legal jurisdiction, personal rights, that kind of thing.
Exactly. We'll pull out the key concepts he's working with, try to understand how he saw the court, how he engaged with it, and, well, ultimately, what happened when these pretty unconventional ideas actually came up against the established legal system. Okay, let's dig in. So Christopher walks into court, and he's facing quite a list of charges. He mentions failure to appear, driving without a license, driving on a suspended license, no insurance, speeding, going over 100 miles per hour, no helmet, and reckless driving. I mean, that's
Well, it's a lot.
It really is. And what's particularly interesting is how he talks about it. He says this isn't his first rodeo, basically. He'd practiced this approach before, and he even called a previous attempt a win because he walked away.
So he sees it as a strategy he's actively developing.
Yeah, seems like it. Like he's refining this personal method. And he jumps right in. From the very beginning, he says, "My name's Christopher. I'm making a special appearance before the court today." Then, almost immediately, he asks, "Is it okay if I step forward and come and pass the bar?" Now, as our guides here, what is Christopher really trying to achieve with this opening from his perspective? It seems quite unusual.
Well, central to his whole mindset is his interpretation of that physical bar in the courtroom. He frames stepping forward as conditionally accepting your offer to board the vessel, but, and this is key only, with retaining all my natural, inalienable, and legal rights.
The vessel, like a ship.
Exactly. The source material explains he believes the bar is how the court tries to grab jurisdiction over you. And if you cross it without stating these conditions up front, you're essentially, in his view, waiving all of your rights and coming under the command of the captain of the vessel.
Okay, so in his head, he's stepping onto a ship, and he needs to be very clear about the terms of boarding. But just to clarify for everyone listening, from a standard legal point of view, does crossing the bar actually mean you're waiving rights or entering some special maritime jurisdiction?
Yeah, that's a really important distinction. It's crucial to understand that in standard legal practice, the bar primarily just separates the public gallery from the area where the court proceedings happen. Crossing it doesn't inherently waive your rights.
Right.
Your rights are generally protected by the Constitution, by procedural rules. Your very presence in the courtroom puts you within its general jurisdiction, pretty much regardless of where you're standing physically. This whole vessel and bar interpretation is very specific to Christopher's philosophy.
Okay, that makes sense. So after this conditional acceptance, he then puts a huge amount of weight on the court's silence. He actually believes that if they don't object after he asserts his rights, they're agreeing with him. He says, he's agreeing by his silence. He's saying that, yes, your natural and animal rights are going to be recognized in the court. How does he try to make that official?
He advises people, his listeners, to always say something like, let it be noted on the court record that there's no objections. His aim is to get that perceived silence, that supposed agreement, formally written into the official court record.
And again, what's the actual legal standing of that? Is silence really taken as agreement in court?
Well, while Christopher reads it that way, legally speaking, silence rarely means agreement or a waiver of rights unless there's a specific law or rule saying it does.
Yeah.
Courts usually need an explicit statement, an overt action,
Not just silence.
Exactly. A judge or a clerk being silent is generally just that, silence.
Yeah.
It's not typically seen as a legal confirmation of whatever claim someone just made.
Okay, this is where his theory takes another, well, really interesting turn. It involves something most of us probably just see as an ID document. His birth certificate. He says, Christopher Illier Fleming is the name on the birth certificate that I have here. What's his belief about this piece of paper?
Right. This is where he introduces the idea of the legal fiction. He claims his parents told him the birth certificate wasn't just proof of birth, but a receipt that came back after the creation of a trust that had been created for my benefit. And he says he is the sole beneficiary of the account, Christopher Fleming.
A trust, like a financial trust, created at birth.
That's his assertion. It leads him to believe that the name on the documents, Mr. Christopher Fleming or Christopher Fleming, is basically a corporate entity, a legal fiction, created by the state for his benefit. And he, the real man, the physical person standing there, is separate from it.
Wow. Okay, so he's drawing a line. There's Christopher, the man, and then Christopher Fleming, the legal entity. That's a fundamental reimagining of identity in the eyes of the law. How does that then change how he sees the judge and himself in the courtroom?
It flips everything on its head in his view. He believes the judge isn't just presiding, but acting as the administrator of this birth certificate trust.
And he, Christopher the man, is the trustee. And in his framework, trustees carry out the administrator's orders.
So he sees himself as sort of managing this account.
Kind of, yeah. But it's a complete inversion of the usual courtroom power dynamic. It's really vital, though, for listeners to know that in standard law, a birth certificate is a record of birth and identity. It's not viewed as a commercial trust document. And your legal identity is tied to you, the person, not some separate legal fiction you can just disown like that in court.
Okay, so based on this belief that he's the sole beneficiary of this trust account,
Christopher then tries to leverage that. He thinks he's allowed to issue or appoint executives for the account, and he actually tries to appoint you, the judge, as the trustee in this matter for me.
right, he's essentially trying to hire the judge to manage the trust for him.
While also challenging the whole basis of the case, he keeps asking, is there a claim against me? Do you have a claim against me? He says things like, I don't see where there's actually any claim where there's someone who's come forward with a claim.
Exactly. He sees the court trying to prosecute Mr. Fleming as what he calls creating more joiner, meaning forcing a connection between him, the man, and this legal fiction entity he wants to distance himself from.
Which is why he says,
He explicitly states, I object. I am not Mr. Christopher Fleming. He genuinely believes that by saying this, he's rebutted the judge's presumption, the presumption that he, the physical man, is representing or standing in for this separate legal entity.
so the logic is, deny the name, break the connection, break the court's power over the real man. But from the court side, how does that kind of objection typically land? If you say, I'm not John Doe, when all the paperwork says you are.
Well, in a conventional court, your legal name, the one on your birth certificate, driver's license, etc., is how the system identifies you for legal purposes. Simply declaring, I am not that name, especially when it is your established legal name, wouldn't, magically invalidate the court's jurisdiction over you as an individual or the charges themselves.
Right. The court generally assumes the person standing there is the person named in the documents.
Pretty much, yes. Until proven otherwise through proper legal channels, not just by declaration.
Christopher describes the whole thing as a game. He even calls it a tennis match or a mind game. He takes the judge telling him not to interrupt as an offer. And he thinks that if he accepts that offer, by staying silent when told, then I'm entering into the jurisdiction. What's the strategy behind seeing everything as an offer?
It seems his core strategy is this constant vigilance against accidentally giving consent. He sees every interaction, every instruction from the judge as a potential jurisdictional offer that he must actively refuse.
So he objects again.
Yes, he reiterates his objection, saying, you do not have my consent to retain me or continue. Then he pushes back, demanding, please, please, please identify yourself. What am I being charged with? He's trying to force the interaction onto his terms, refusing to play by what he sees as the court's rules or accept its authority implicitly.
And this leads to a really interesting moment near the end. He says, I wish to plead guilty to the facts of the case, but then he clarifies his reasoning. You can't plead guilty to the facts. You have to plead guilty with the understanding and the knowledge and the intent that you've done something wrong.
Yeah.
He's making a distinction there.
He is. He's touching on a fundamental legal concept. The difference between the act itself, what lawyers call actus reus, and the mental state or intent behind the act, the mens rea. In many criminal offenses, the prosecution needs to prove both happened. Christopher seems to be suggesting he'll admit the facts occurred, like, yes, the car was speeding, but not that he had the necessary wrongful intent. Maybe he thinks this avoids a full admission of guilt.
Could that work? Pleading guilty only to facts?
Generally, no. For a court to accept a guilty plea, the defendant usually has to admit to all the required elements of the crime, and that often includes intent. Just admitting the facts without acknowledging the necessary mental state probably wouldn't count as a valid guilty plea for most criminal charges. The court needs the whole package, so to speak.
So after all this intricate web of arguments, the specific language, the attempts to redefine the entire situation, after all Christopher's efforts to play the game by his rules, what actually happened? What was the consequence?
Well, despite the complexity and the conviction behind his arguments, Christopher states he was ultimately taken in custody. He mentions he did 36 hours on that one in Los Angeles County.
So it didn't achieve the outcome he was presumably hoping for in this instance.
It seems not in this case. Although, interestingly, he still encourages people to check out his next one, another case, which he considered a win.
Yeah.
So he clearly didn't give up on the approach.
Okay. So what do we take away from all this? We've really dug into Christopher's detailed account, his courtroom strategy. It's all hanging on these very specific, very personal interpretations of legal identity, jurisdiction, consent.
Yeah.
We've seen how he tried to reframe the whole process as a kind of game, using ideas like conditional acceptance, the legal fiction tied to his name, and treating the court's silence as agreement.
It definitely shines a light on how individuals can perceive and interact with the legal system in ways that are, well, miles away from standard legal practice. It's based on their own distinct understanding of rights and authority. And it also gives us a fascinating glimpse into just the communication dynamics inside a courtroom, doesn't it? How the different players can have fundamentally different views on what's even happening in the interaction.
Absolutely. Which leads to maybe a final thought for you listening. Considering Christopher's really detailed methods and his unwavering belief in them, even though the outcome here was custody, what does this whole story tell us about the power of personal belief? About these alternative legal theories when they come face to face with long established institutions and their processes? It's definitely something worth thinking about.
Okay, so basically went into court on Mona on 10/11, and one of them was for a failure to appear, driving without a license, driving unsuspended, driving without insurance, and speeding or something. And the other one was for, I'm assuming, that Whittier case when I got pulled over for um, driving without a license, driving over 100, driving without a helmet, reckless driving, all that shit. But to make a long story short, I'll cut to the video in a second, or the audio. But you'll see, like, after I got arrested for this one, they brought me back into court, and I just pleaded it out, and they wrapped up like 3 other cases. So I just served jail time on like $1,700 worth of fines or something like that. But I had like 4 cases, so I was just practicing. You know how it is. Like, I've done this so many times before, but I'm still learning. Here we go. Hey, good afternoon. Oh, my name's Christopher. I'm making a special appearance before the court today. Good to see you. Long time no see. Okay. Is it okay if I will step forward and come and pass the bar. Okay. Okay. I conditionally accept your offer to board the vessel. Is it alright with you if I do so with retaining all my natural, unalienable, and legal rights? Okay. Let it be noted on the court record that there's no objections and that I am now entering. And you notice how they stay silent right there, because they're never gonna. They can't deny the man the rights. They know that you have unalienable, natural born rights, so they're not gonna deny you your rights. So the reason why he just remains silent right there is because it's his tacit agreement. He's agreeing by his silence. He's saying that yes, your natural and unalienable rights are going to be recognized in the court. We can't take those from you. Okay? So like that's what that little pause was. If you notice, like, catch that watch. They'll always do that in court. They'll remain silent, and you want to get that silence on the record. So you always want to say, let it be noted on the court record there's been no objections, or let it be noted on the record that no one objects to me appearing as such, or something like that. You always want to get the silence on the record. I'm just going to go back over that one more time. Entering this proceeding. Okay. Is it okay if I will step forward and come and pass the bar. Okay. They want you to walk past the bar. That's what that little thing is. It's the bar. They're trying to get you to pass it so that you're in their jurisdiction. You're boarding the vessel. He's the captain of the ship. He's the one who calls all the shots. So what's going to happen is that you're waiving all of your rights basically, and you're going under the jurisdiction of the captain of the vessel or whoever it is who is the administrator of the account, of which they're presuming the presumption is that they are the administrator, that the judge is going to be acting as the administrator, and that the trustee is myself. Okay? Because there's three forms. There's the shareholders, there's the executors, and then there's the trustees. The trustee's job is to fill out the orders of the administrator. So that's what they're trying to get me to do here.
Okay, I conditionally accept your offer to board the vessel. Is it alright with you if I do so with retaining all my natural, unalienable, and legal rights? Okay, let it be noted on the court record that there's no objections and that I am now entering these proceedings with a full reservation of my natural, unalienable, and legal rights. Is Christopher Ellier Fleming is the name on the birth certificate that I have here. I was given this when at my birth. My parents gave this to me, and they said that this is a receipt that came back after the creation of a trust that had been created for my benefit. You see, I'm the sole beneficiary of the account, Christopher Fleming. My name is Christopher. I don't know. See, because I can't remember. I barely just was. You are charged. I'm charged? Excuse me, sir. I'm charged?
That's where I should have told him that originally he cut me off. See, so he's out of turn. And now he's going to tell me that I'm out of turn because I'm overspeaking him. See what I'm saying? It's just a game. It's literally, that's why they call it court. It's like a tennis match, like a tennis court. You know, it's like a mind game back and forth between me and him.
Okay, I'm gonna let you finish. Sir, on and for the record, I understand that it is against the statutes for people who are employees of the U.S. government to violate those statutes that you have stated. Now, as I made the special appearance, I came forward today and I specifically stated I was not Mr. Fleming and I was not Christopher Fleming, that I am making a special appearance here before the court as a third-party administrator of the account. See, I believe that I am the sole beneficiary, and therefore, since I have the birth certificate here, which I'd like to put on the record, that I have a birth certificate, so therefore it's my understanding, and please correct me if I'm wrong, that I am allowed to issue or appoint executors for the account. So therefore, I can also account or issue trustees. Therefore, I would be appointing you as the trustee in this matter for me to carry out and proceed and see where we're going to go with this, because I don't see where there's actually any claim, where there's someone who's come forward with a claim. Is there a claim against me? Do you have a claim against me? Are you?
Bam, creating more joinder. Doesn't answer any of my questions, and then tries to create joinder between me and Mr. Fleming, the legal fiction. Okay, so there must be no claim against me, and they're just going to proceed. This whole thing is unlawful. I did everything I was supposed to do. I identified myself as a beneficiary, identified myself as the executor. I appointed him as a public trustee, and he just is completely lawless.
Are you claiming injury? I object.
You are Mr. Christopher Fleming. More joinder. Just keep on with the joinder. Creating joinder between me and Mr. Fleming. Regardless, anything they have to do. Even if it's in fraud.
I object. I am not Mr. Christopher Fleming. The title Mr. is only attributed to legal fictions. Christopher Fleming is a legal fiction that was created at my birth for my benefit.
Perfect. Perfect example. See, I rebutted his presumption. His presumption, the presumption of the court is that they're operating under the presumption that me, the real man, am standing in place as surety for the legal fiction Christopher Fleming or Christopher Ellier Fleming or Mr. Christopher Fleming or whatever. Mr. Fleming. When I rebutted his claim, he just continues, and you'll see how he watch.
Benefit. See, I'm Christopher.
See, that was an offer. He's going to ask me not to interrupt him one more time. Okay? That's an offer he's offering me. Okay? So, by me accepting his offer, then I'm entering into the jurisdiction. I think that at this point is where he actually got the jurisdiction over me.
Can you please, excuse me? I object. I object. Are these men public servants? I object. Are these men public servants? They do not have my consent. You do not have my consent to retain me or continue. Please, please, please identify yourself. What am I being charged with? What am I being charged with? No, I'm not Mr. Fleming, sir. Please, please don't. Every opportunity to have a say in what happens. I need to know whether you want to hire your own attorney, whether you will be asking for a court-appointed attorney, or whether you wish to represent yourself. Sir, I wish to plead for Christopher Fleming. I wish to plead guilty to the facts of the case.
Bam, points to public defender. So you can't plead guilty to the facts. You have to plead guilty with the understanding and the knowledge and the intent that you've done something wrong. You always have to understand that you've done something wrong. You see, you can't just plead guilty to the facts.
I need all my stuff, please. We'll bring it.
Bam, in custody. Did 36 hours on that one in and out of LA County Jail. And learned a lot. So came back and did the next one. Hope you'll check out the next one. It's a little bit shorter, but I walked away. I consider it a win. Okay, so thanks for watching and subscribe later.